Dr. Mtungo, welcome to the big interview on NTV.
Thank you.
Now, on the 27th of August 2010, when we promulgated the new constitution, what vision did you have for this nation? That's 10 years ago.
For me personally, it's I looked at that opportunity as, with a lot of optimism because of the vision of the constitution, the changes that were envisioned by that constitution, and I was certain that Kenya would start this journey of building a society on the vision that the constitution had.
Now, the preamble of this new constitution, we still call it new, but it's a 2010 constitution, says, we, the people of the Republic of Kenya. What is the significance of those words? What's the aspiration behind those words?
The word people, has been used for all manner of things. A lot of sins have been committed in the name of the people. If you want to know who the people are, is to look at the process itself, how participatory it was, whether it's a Judicial Service Commission, whether it's IBC, there is always a provision that that authority they exercise is derived from the people. You go to the security, Article 238, it also says that the people are sovereign, supreme.
And so we, the people, had a vision in passing that new constitution. Would you say, as a nation, we've done enough to implement that vision?
I look at it this way, Joseph. This movement to amend the constitution started in the 60s. Immediately after independence, the people who basically said, particularly around land, they said the British stole our land, and now we are buying back. There were some people in this country, Kagia, Pinto, Odinga. It was a group, and the Mau Mau movement, those who survived. There was that group basically saying, how can we buy from these people what they store from us? So the land question, which was also addressed by 2010, has that history. There hasn't been a consensus on the implementation, because the forces that are against implementation are powerful, and they are clawing back, or they're demolishing the pillars of that constitution. But the other forces, and you have seen them in civil society, people who deal with public interest litigation, when they say Parliament shouldn't do this, others go to court and say the president should swear judges. He cannot say he can't swear them. So if you look at those forces from 2010, what is healthy about it is that was expected. It was expected that some forces will find the constitution too progressive. Okay? The president keeps on saying that how come he doesn't appoint judges? Why can't he be given 3 names, when he chooses the CJ? He has refused the position that actually when it comes to appointment of judges is a rubber stamp. Once JSC has done his work, he has to swear them in, except the Chief Justice and Deputy Chief Justice, whose nominations he has to hand over to the Parliament for vetting. So there are people who are saying, no, you cannot amend because you haven't implemented, the Constitution. The others who are saying, no, the best way is we capture state power and the political power, and we have the political will to implement this progressive Constitution and rescue the weaknesses of the Constitution, because like any Constitution, it has.
Miguna's litigation in court, what's your view on that?
Miguna has suffered gross violation of human rights. Really, when you look at the Constitution and the law, and the courts have decided as much, that is entitled to those rights. The fact that the government still subverts those, orders given in favor of Miguna, including compensation for the destruction of his house. For me, whether people like Miguna or not, that's not the issue. The issue is that the consequences of the Miguna case are very frightening. That you can get validation of your rights in the court of law, and they are not realized, okay? People basically say, utadu, and that is worrying because it can happen to you, it can happen to me. It can happen to any particular citizen. So for Miguna's issue, I take the legal position, which is there's no reason why the court orders should be disobeyed. He should be allowed to come in with his ID card or a temporary permit, whatever. He never, in my view, under Article 16, he never ceased to be a citizen of this country. And there are a lot of people who I've talked to tend to personalize this issue. And that is very painful to me because the Constitution protects everybody. Miguna rubs people the wrong way, particularly when he starts using his DNA kit. I once wrote to him and I said, my friend, if you say my father is not my father, I'll kill you.
In your time as Chief Justice, what was your experience of working with the executive and parliament?
This was cordial. What we did in the judiciary, we realized that the notion of separation of powers, the separation of the three arms, is good in terms of theory, but when it comes to national interests, when you are fighting pandemic, when you are fighting terrorism, when you are fighting famines or earthquakes, they collapse into one because it's the national interest that you focus on. So we focused on what we called constructive dialogue. Okay, constructive dialogue where the independence of each arm was respected. And for the judiciary, we set up what we call the Judiciary Training Institute. That's where we used to have the discussions. When the government was unhappy about a particular thing, we say, yes, come to Judicial Training Institute, we talk. We talked a lot about decisions against government. We're trying to justify why they were made. We allowed government institutions like KRA to come and tell us how our decisions impact the national interest. And we were also able to talk to them about how the judiciary functions and so forth. So during that period, that was established, and I'm quite certain, it's still there as an institution, because you see, that kind of discussion in 2015 helped a lot. 2015, if you remember, the three arms were in court. That was during the Cholet issue. The executive wanted to remove some of the commissioners. Parliament had issues with the judiciary. So this issue went to court. And I remember the President, Uhuru, convened a discussion of Muturi, myself, and him about that case. And my position was, this is good that we have a dialogue about this issue. Let the courts decide. And the courts decided, and we all abided by that particular decision. Of course, when I left, I was a bit shocked when the president said I was activist CJ. The speaker said the same thing. I wanted to go and see the president and basically say goodbye. He wasn't available, so I wrote to him, which was fine, to tell him how the judiciary was. I still remain very grateful to the Speaker of the Senate, Ekwe. He invited me to talk to the Senate about what I had done and so forth. Of course, I think Justin Muturi thought I was an activist, so I wasn't worth inviting. But that is neither here nor there. I valued that collaboration and consultations that were institutionalized so that no particular arm felt either bullied or whatever.
Right. Now, Dr. Mutunga, earlier you made reference to that issue of the president's role in swearing in judges, and you have this issue of these 41 judges. So the question is, should the president swear them in and obey court orders?
We had that issue also in 2015. JSC appointed judges, and the president chose to swear some and not the other. And I remember as Judicial Service Commission, we sought audience with President Uhuru Kenyatta, and he raised the same issue. I don't want to be a rubber stamp. I have to participate in this. And we said, that's okay, Your Excellency. You know, the fact of the matter is legally you are, a rubber stamp. But this is how you are not a rubber stamp. You have the AG and the chair of the Public Service Commission as your representatives in the Judicial Service Commission. You have two appointees, a man and a woman, who sit in the Judicial Service Commission. And when we interview judges, the public should know that the Judicial Service Commission seeks recommendations about the suitability of the candidates from NIS, which is in the executive, certificate of good conduct from DCI, that's executive, KRA, to make sure that people are paid taxes, that is also executive, Anti-Ethics and Anti-Corruption Commission has to give a report as well, okay? And then we go to the university and get reports from Higher Loans Board, Higher Education Loans Board, I think it's called. And those are used. And when we get those reports, of course, if Joseph is applying and there's something negative in the report, the JSC, in implementing the Constitution or following the Constitution, will bring it to your attention and say, Joseph, we are told that you did this and that. And members of the public come in, you know that. They come in and they say, this guy shouldn't be in because of this and that. So the JSC gives the candidates what we call due process. But we realize that the president had a point, because he was saying, look, I can get information about Joseph outside these institutions of the executive. Suppose I get evidence against somebody from MI6, CIA, Mossad, or FBI. And we said, yeah, that is fine, as long as you bring that evidence to the Judicial Service Commission so that we confront the candidate, with that evidence. So my position is that the president has no power, at all under the Constitution to refuse, to swear, the 41 judges. And the other question you asked is, of course, about the
budgets. The budgets, yes.
And resources.
Whether the executive or parliament should cut the judiciary budget.
If the people are the ones who are giving parliament, the authority and the executive to act in their interest, where does parliament get the power to starve the judiciary of resources? The resources belong to all of us. So the notion that the executive and the parliament have resources and they can tell you oh, we won't give you resources because of A, B, and C. It takes us back to what we refused. That was Moi's policies of siasa mbaya, maisha mbaya. So the judiciary is being punished because they're saying, oh, you know, you are not towing the line. What line is that? When the money is not there, the courts that are being constructed are constructed for the people. But this tug of war, in my view, is totally unconstitutional. And because there is a problem, maybe decisions are being made against the executive. You say we will revisit, we will do this. It's not good for the country because the judiciary is one of the key institutions in the country. And I remember in those discussions we had with the executive and parliament, my advice to them was always this, that make sure that the judiciary is independent. Because if you capture the judiciary, it can also be captured by those who come after you. And where will you go when they come for you?
Let's talk about the representation of women. Have we taken care of the representation of women in Parliament and devolution? What's your take on that?
Parliament has let down, you know, Kenyans on this particular issue. And in terms of politics, the system looks very patriarchal, very male chauvinistic, very anti-women, okay? Because we have had 10 years to implement that, okay? And it hasn't been implemented. And now we have reached a stage where Parliament has to be dissolved. If the law is followed, Chief Justice recommends to the President, if you look at that section, that article, it actually says that the Chief Justice shall and the President shall. So there's no option but to do what that section, you know, demands. So I think it's again another blot on the implementation of the Constitution. It wouldn't have cost us anything, you know, to implement what is the minimum. You know, it's a minimum. It's not even 50%. It's 33 point whatever. And that's a great shame. Devolution for me is one of the great pillars of that particular Constitution. And it shouldn't be smashed. You know the executive has been clawing back. The provincial administration has never been abolished. The whole question of restructuring, you know, devolution and so forth. We have kind of parallel systems, and it's very expensive. And then the counties now are saying, well, you know, we are not getting developmental funds. So it's something, again, that goes back to the implementation.
Now, Dr. Mutunga, at the moment there's a big debate about amending the Constitution. And the question is, should we, first of all, fully implement the Constitution, or should we amend?
My view is that, and that has been my response to BBI. What I saw in BBI that captured my imagination is this national conference that is supposed to project Kenya into the 10 decades from now, 100 years from now. It's borrowed from the Chinese, as you know. The Chinese project into the future 300 years, and then they split the years into 50-50. So you can imagine, of course, that they expect by 300 years, you know, 3 centuries, there will be the superpower in this country. So, but here, the National Conference would have debated the Kenya we want, you know, in what? That will be what, 21 something. That's the only thing I saw that I thought this this is a good idea. But when I looked at these other recommendations, everyone I read, my question was, why haven't you implemented the Constitution? If you are talking about national unity, why is Ruto out of this? Why are the other communities, in this country excluded? Because it's about the big five, not the animals, but the five communities that basically think that they have the right to rule this country, and they have their alliances and their barons come together, and they can form one alliance, then they fight, then they form another one, and they fight. Totally ridiculous, because they should be able to rotate. You can imagine if the five of them started rotating after independence. If Raila succeeded Moi, and then after Raila is succeeded by Kalonzo, now we will be looking at Wycliffe Mudavadi or some other baron from the Luhya nation. I don't think that we need to amend the Constitution. In fact, my view is that we amend this Constitution so that it gives us a different society in terms of corruption, in terms of leadership, and so forth. And then the amendments should come from the young people who didn't participate in the Constitution, 2010 Constitution. They didn't participate. They have their own ideas about it. So they can rescue the weaknesses, of this Constitution. So for me, I say maybe the best thing is we get an alternative political leadership that has the political will to implement. But then it also looks at the weaknesses of that Constitution and carries out reforms, because there are some people who basically say there are certain weaknesses that we have to, to look at.
What vision did the Constitution have about land, which has brought a lot of chaos and suffering in this country historically?
The Constitution doesn't solve the issue, but it mitigates it in this sense. First, foreigners and foreign companies that own land are now reduced to, owning that land on the basis of leases, 99 years. So the freeholds are gone, and that's a mitigation, because before that there were no, some people could hold land in perpetuity. The other thing that the Constitution does is to create a land law regime called community land, so that where you have not commodified land by giving title deeds, the community can choose to use the land collectively. The community can use the grazing areas, the watering areas as a community. Of course, if you look at Article 40 of the Constitution, it protects private property. And that means land that those who are rich, families that are rich, can pass it on to their kids. So property profits goes on, and that's how you get political leaders reproduced. So you still ultimately get to this issue, which is fundamentally political. Where will you get a political leadership that is at least ready to discuss this particular issue and find solutions that diffuse the tensions that are currently there, which are not very healthy?
And finally, Dr. Mutugu,
Yeah.
What do you do in retirement? What does the Chief Justice do in retirement?
I've been writing. I've been thinking a lot. I've been reading a lot. I've lectured a lot. I've been involved in consultancies, you know, and I'm supposed to build what is called the office of the former CJ, which is under one of the acts. The act provides for that office and staff and chief of staff, you know, within it, and that office can also be supporting, you know, the institutions. I see it as an office that can mediate, like this issue of the judges. I've tried to do it, quietly, you know, reminding people of the consensus that we reached in 2015. And it can also be a site for all the retired judges.
So you're still active, essentially?
How in this country do you retire when the struggle continues? You can't. So I spend a lot of time with the youth movements, the artist movement, and social justice movements. I get invited a lot, you know.
That's a bit like your former self, the one that we know
yeah,
about from
yeah. But this time, you know, is people want to learn lessons of the past,
yes,
which is okay, you know, so that they don't repeat our mistakes.
Are you allowed to practice law as a retired?
Yeah, I can. I have a practicing certificate, senior counsel, and I had a farm before I became Chief Justice, and I sold it when I became Chief Justice to relatives, and then when I came back, they hadn't paid me. I took it back. And I am a consultant there, so people who want me to write opinions come through the firm. I've just finished consulting for the Constitution Review Commission of the Gambia.
Right.
With some professor called Fiat Joe from Ghana. They decided that the constitutions of Kenya and Ghana were the ones they wanted to look at closely. So I went there and I told them what the weaknesses were and so forth, and that was pretty interesting.
But
so,
we wouldn't see you going to take a matter to court. That would be quite intimidating for whichever judge.
No. There is a convention that if I wanted to go to court, it will be outside the jurisdiction. And I think that makes a lot of sense. As a retired Chief Justice, you are head of the judiciary. I don't know whether I will intimidate the courts, because I have 2 cases in court and they have taken too long.
Right.
So I don't know whether I'm hated there or what. So they are still there. I didn't pursue them when I was Chief Justice, you know, because it would have been improper.
Yes.
During that time. And this is a case about my divorce and about matrimonial property. And the other side, of course, thought that I would influence the judges and so forth. So we put it on hold until I left.
But it's been a while now. Kenyans will be surprised that even for someone of your caliber, you still have matters which are stuck in the court process.
Yeah. I have a matter in the Court of Appeal and a matter in the High Court. And it was fast-tracked, but it hasn't been heard. But we just hope with this new system of electronic filing and whatnot. I've asked the courts to, fast-track it. Yeah.
Now the CJ's office, that's it's quite a heavy responsibility. Away from it, do you feel is your burden lighter?
Right. I mean, 16th of June, 2016, when I left that place,
yes.
I tell people this, that I found myself in the shower every morning singing, "I'm free at last." Which is true.
Was it that?
Oh, you know, people should sympathize with the president. He deals with so many balls in there. Institutions are very difficult to run. And the divisions that you find in this country are reflected in the judiciary, whether it's ethnic, religious, regional. And so we were trying to build the institution that stands together so that when you talk about independence of the judiciary, it's not just about external pressures, but it's looking at the internal pressures as well. But it's very, very, very stressful.
How did you keep sane? And when you're in that kind of seat, what was your recourse?
Yeah, well, I did a lot of meditation and yoga and and exercise and that calms you down a lot. Reading what you like, that's also very, very, very calming. And in the judiciary, I created what I would call collective leadership. There was some organization called JELAC, which was Judicial Leadership Advisory Council, which was broad. It brought together the president of the Court of Appeal, the presiding judge of the High Court, chief registrar, myself, Judicial Training Institute. So that also helps because you don't feel responsible for particular decisions. They were taken collectively, and the backlash is not just you, it's the institution. But of course, that office is very political. So if anybody tells you that judges are not political, that's a lie. You don't survive that office if you don't play serious politics.
Do you have any regrets from your time in service?
No, not at all, because it was an experience that was good for me. I was into activism. I used to look at the state as this engine that is so destructive. But I went there and I realized, no, it's not that homogeneous. It's just the leadership that is a problem. Found civil servants who are very patriotic, who love this country, but although they don't make decisions and they are very unhappy, those who are on top are making various decisions and so forth. So the state is not that homogeneous. It has its parts. And it helped me understand the difficulties of ruling, the difficulties of running a country. I guess if I was 35, I would have been prepared. That 5 years would have prepared me to get into political office and run the country. But even if I was given that job on a silver platter, I won't take it.
No,
it will kill me. It's a difficult job.
Right. The attire of judges and to some extent lawyers in court, we still find it very formal, and sometimes people find there is almost that distance between the citizen and these high-powered people dressed in these very strange costumes.
We dealt with that since August 2012. I remember I wrote a letter, a paper, which I presented in the colloquium of judges. It's called Dressing and Addressing, the judiciary and the history of it. And in that paper, I traced the history of the colonial robes and the wigs. I also traced why judges play God by allowing themselves to be called my lord. It traces back to a feudal system where the lord of the manor had a court, but he was also a bishop. but he was also the aristocracy. So he was Lord. And so when people went to his court and said, "My Lord, my prayer this morning," that was the context, okay? And we even started changing the structure of the courts, because if you go to the High Court or the Supreme Court and you go to the CJ's old court, which is court number 1, you get to see that hierarchy. You know, the lawyers have to look up. That's where the judges are. They are seated up there, and they are down here. So when they say, you know, "My Lord, my prayer this morning," it's judges playing God. So we were of the view that the Kenyan people remember the colonial robes when a lot of people were condemned to death. The Mau Mau and all. They were very particular, saying that judges should not wear those robes and wigs for that reason. And so we discussed it and we said, okay, we'll get our own robes and we don't wear wigs. And I think the only mistake I regret making was that I didn't take all the wigs and put them in the museum. So, and the robes too, the marindas that are scarlet.
Yes.
So I think the debate still continues. If you look at the courts, there are people who wear them, yes, others who don't. And we also decided that judges will be Mheshimiwa. So instead of saying "My Lord," we will say "Your Honor." And that is the way they, the judges should be, addressed. So the Constitution itself has these decolonizing attributes, and in terms of dress and so forth, is one of those. Yeah.
Dr. Mutunga, let me thank you very much indeed for your time.